Freedom is expression.
Freedom is
आजादी
expression.
फारस
Freedom is
है।
expression.
Freedom is expression.
Freedom is expression.
Libertate înseamnă a avea puterea de a te exprima.
Freedom is expression.
Many people in the world lack the fundamental freedoms that are universally recognized
as essential for a free society.
Freedom is expression.
These freedoms are
Freedom of the press.
Freedom of speech.
and freedom of religion.
Freedom is expression.
With freedom of expression will there be true peace.
الحرية التعبير.
When people's voices are silenced,
we must speak out for justice.
In a free society, freedom of expression is not just our right.
It is our responsibility.
Freedom is expression.
自由は表現法です。
Freedom is expression.
自由是表情。
Freedom is expression.
The art of peace is now.
Benjamin Gitlow had been a member of the Socialist Party during the 1920s. He was arrested and convicted for violating the New York criminal anarchy law of 1902. This made it a crime to attempt the violent overthrow of government. Gitlow's movement of 16,000 copies of the left-wing manifesto violated this Criminal Anarchy Act. The pamphlet went on to promote the creation of a socialist system through the uses of strikes and class action in any form. Gitlow was convicted. He appealed the decision because he thought that his First Amendment right to freedoms of speech was violated. Although the New York courts held that the communists must be held accountable for the results of their propaganda, the Supreme Court ruled in favor of Gitlow. It stated in its decision that, for present purposes, we may assume the freedom of speech and of press are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment.
The case of G. versus Humphreys challenged State College's suspension and termination of Gerald G., who was a white professor. He was said to have harassed students at a historically black Florida A&M university. G. used the phrase, "beep" mentality in a conversation with students, which he prefaced by explaining it was a popular phrase. This offended some of the students.
At a school assembly of approximately 600 high school students, Matthew Frazier made a speech nominating a fellow student for elective office. In his speech, Frazier used what some observer believed was a graphic sexual metaphor to promote the candidacy of his friend. As part of a disciplinary code, Bethel High School enforced a rule prohibiting conduct which substantially interferes with the educational process, including the use of obscene, profane language or gestures. Frazier was suspended from school for 2 days.
In 1917, Congress passed a law called the Espionage Act. The law said that during wartime, obstructing the draft and trying to make soldiers disloyal or disobedient were crimes. Almost 2,000 people were accused of violating this law and were put on trial. Charles Schenck mailed thousands of pamphlets to men and women who had been drafted into the armed forces. These pamphlets said that the government had no right to send American citizens to other countries to kill people. The government accused Schenck of violating the Espionage Act. It said that Schenck's pamphlets were intended to weaken the loyalty of the soldiers and to obstruct military recruiting. Schenck answered by saying that the Espionage Act was unconstitutional. He said that it broke the First Amendment. After working its way through federal courts, the case was judged by the Supreme Court in 1919. Justice Oliver Wendell Holmes wrote the decision for the unanimous Supreme Court. It supported Schenck's conviction, saying that it did not violate the First Amendment.
Marvin Miller was convicted for mailing illustrated brochures advertising adult books. The California Appeals Court used the test previously pronounced by the court to uphold Miller's conviction. The Supreme Court took up the case as an opportunity to reconsider its previous holdings. The resulting 5-4 decision imposed a new test for determining vulgarity. In a decision written by Chief Justice Warren Burger, the court imposed a new 3-part test for determining whether a work was obscene. Burger wrote, "The basic guidelines for the tier of fact must be A, whether the average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient interest. B, whether the work depicts or describes in a patently offensive way sexually conduct specifically defined by the applicable state law. And C, whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. This case involves the application of a state's criminal obscenity statute to a situation in which sexually explicit materials had been thrust by aggressive sales actions upon unwilling recipients, who had in no way indicated any desire to receive such materials. This court has recognized that the states have a legitimate interest in prohibiting dissemination or showing of obscene material when the mode of giving out carries with it a significant danger of offending the sensibilities of unwilling recipients, or of exposure to juveniles. It is in this context that we are called on to define the standards which must be used to identify obscene materials that a state may regulate without infringing on the First Amendment, as applicable to the state through the 14th Amendment. Marvin Miller was found guilty of the misdemeanor of distributing material that could be considered to be objectionable in nature.
The case of Feiner versus New York was fought because the petitioner, Feiner, was convicted of disorderly conduct for refusing to stop giving a speech on a public sidewalk once the crowd was getting a little rowdy. The petitioner was addressing a group of 75 persons gathered on the sidewalk. The original purpose of the speech was to invite listeners to attend a meeting, but he also made some offensive remarks towards some political officials. Later, a neighbor complained to the police, and 2 units were dispatched to the scene. At that time, people were spilling out onto the street and disrupting traffic. One officer asked the petitioner to stop talking, but he refused several times and was eventually arrested.
The case of Wisconsin versus Mitchell arose from the breaking of a Wisconsin law. Defendant Mitchell's sentence for aggravated battery was enhanced because he was intentionally racist. The State Court of Appeals rejected his challenge to the laws constitutionally, but the State Supreme Court reversed, relying on RAV v. St. Paul 505 U.S. 377. It held that the statute violates the First Amendment by punishing what the legislator has deemed to be offensive thought, and rejected the state's contention that the law punishes only the conduct of intentional victim selection. It also found that the statute was unconsensually overbroad because the evidentiary use of a defendant's prior speech would have a chilling effect on those who fear they may be prosecuted for offensive, subject to penalty enhancement.
The case of U.S. versus ALA addressed the problems associated with the availability of Internet pornography in public libraries. Congress enacted the Children's Internet Protection Act. Under CIPA, a library may not receive federal assistance to provide Internet access unless it installs a software to block images that constitute obscenity or child pornography, and to prevent minors from obtaining access to material that is harmful to them. The district court held these provisions facially invalid on the ground that they induce public libraries to violate patrons' First Amendment rights.
The case of Tinker v. Des Moines started in December 1965. Vietnam War protesters decided to wear black armbands during the holiday season to publicize their views. School officials decided that students wearing armbands would have to either remove their armbands or be suspended from school. When Mary Beth, Christopher, and John Tinker and other students wore black armbands to school, they were suspended. They sued the school. The Supreme Court sided with the Tinkers. It saw the black armbands as a form of political speech and stated that schools had to show evidence of the possibility of a substantial disturbance before free speech could be limited. By siding with the students, the Supreme Court ensured that they had the right of free speech within schools as long as it did not disrupt the learning.
While the Republican National Convention was taking place in Dallas in 1984, Respondent Johnson participated in a political demonstration protesting the policies of the Reagan administration. The group marched through the streets, chanting political slogans and spray painting walls of buildings. Johnson did not participate in these activities, but however, he did burn an American flag. Of the approximately 100 demonstrators, Johnson alone was charged with a crime. The only criminal offense he was charged with was the vandalism of a respected object. After a trial, he was convicted and sentenced to 1 year in prison and fined $2,000.